Hi everyone, and welcome to Law Chat with John and Amy. I'm John Yulian.
And I'm Amy Pliafico. This week's question is, can I sell my house while I'm in a Chapter 13 bankruptcy?
As a reminder, a Chapter 13 bankruptcy is a restructuring, a reorganization by an individual or a married couple. When it's a married couple filing, it's called a joint bankruptcy filing. The Chapter 13 plan is often and typically 3 to 5 years in length. And during that period of time, if the individual or the married couple own a home, they may very well want to sell the home. In a Chapter 13, there are specific rules that have to be followed in order for a sale of real estate to occur. Amy, can you discuss what the procedure is to sell a home when you're in a Chapter 13 bankruptcy?
Yeah, the first thing that needs to happen is your realtor needs to get approved by the bankruptcy court. So there are certain documents that you'll need, including your listing agreement, and your realtor will need to sign an affidavit. Those then get submitted to the court. As long as the person is charging a reasonable rate, generally the court's going to approve it. And they don't get paid if they don't get approved, so it generally incentivizes them to get the paperwork back to us as soon as possible. Next, you're going to put your house on the market, and once you've accepted an offer and have a purchase and sale agreement, it'll need to get filed with the court with a motion to sell the property. That motion outlines what property you're selling, how much you're selling it for, how it was marketed, what liens need to get paid from it, and then what's going to happen with the proceeds. Are they all exempt because you have a homestead in the property? So you're going to keep them all, or are some of them getting turned over to the trustee to fund part of your plan? The judge will set up a hearing date and also set up a deadline for anyone else who wants to put an offer in on your house or to object to the sale to do so. And then hopefully at the date of your hearing, your motion gets approved and then you can close on your house. Just a reminder that does take a while. You're never going to be able to do a short turnaround time on terms of your closing in a Chapter 13 because you do need to have that hearing date. And then after that, you're going to need to file an amended plan, most likely because if your plan provided to repay mortgage arrears, you no longer have a mortgage, so that'll need to be changed. Plus, wherever you're living now, if you're renting or moved into a different house, your mortgage payment and your new rent payment are probably not going to be exactly the same, so your disposable income will have changed. So we'll need to file new schedules, which will require a new amended plan. And then once you actually have the closing, you'll need to provide the trustee a copy of the HUD settlement sheet, and you will also need to file a report with the court on the sale and exactly what happened with it, and include in closing another copy of the HUD settlement sheet.
So that might sound like a lot, but it really is not as complex a process as it may appear. It's just a way for the court to be able to oversee what is transpiring and where the funds are going from the sale. I think that's a good point to stop for today, Amy.
Thanks for joining Law Chat with John and Amy. We look forward to chatting with you again next week.
If you have a question or comment, feel free to email us at info@yulianlaw.com. Remember that Law Chats with John and Amy is intended as a general reference and considered general advertising, and listeners should check for changes to any applicable laws and consult with an attorney on any legal issue. The information provided does not constitute legal advice, and any thoughts or commentary by the podcasting lawyers is provided as a service to the community and does not constitute solicitation of legal advice. The lawyers in the law firm of Yulian & Associates PC make no warranties and disclaim all liabilities for damages resulting from its use. Nothing provided in the podcast should be considered a substitute for advice from counsel. No attorney-client relationship is formed by listening or participating in this podcast, and in the event that the podcast receives emails about the subject matter, no attorney-client relationship is created via the email communication.